Obey court orders first, even if dem dey wrong. Lawyer don warn Senate over Natasha suspension. Welcome to Sinok Media. We wan thank country people wey dey view our channel. Abeg, if una never subscribe, make una do so now. Put on your notification button. E go give you alert once we drop update. Make you like, comment and share our videos. A senior advocate of Nigeria, Oba Maduabuchi, he don criticize the Federal High Court judgment when he ordered the recall of suspended Senator Natasha Akpoti-Uduaghan. He dey argue say the court contradict itself when e find no limit for Senate rules, but e con dey at the same time dey declare the suspension excessive. As im dey tok for one television interview, Maduabuchi e con highlight wetin e describe as a glaring inconsistency for Justice Binta Nyako judgment. He say the court say dem no get limit contained for the rules and regulations of the Senate as to how long you go fit suspend somebody. He say that na part of the judgment. Maduabuchi explain. He say if dem no get limit for the legislation, he say the court no be legislator. He say the business of the court na to interpret the law as e be, no matter the hardship wey e give anybody. The senior advocate come question the court logic to declare the 6-month suspension excessive after im don acknowledge say the Senate legislation e no get limit as e exist for the Senate rules. Im come tok say you don tok am finish say e no get limit. E now dey left completely for the discretion of the Senate. Then how can you now come introduce limit and come decide say e dey excessive? They say no be your business say 6 months dey excessive. Maduabuchi come argue say the court come exceed im constitutional role because e come create limitations when e no exist for law. According to am, only the judge say something no get limit, then you come dey say e come dey excessive. E come say the court suppose to interpret existing law, no be to create new standard. The senior advocate come suggest say the proper course of action go be for the court to recommend legislative amendments rather than to impose im own interpretation of wetin constitute excessive punishment. Maduabuchi come clarify say the judgment address two distinct matters: the suspension issue and the contempt charge for Akpoti-Uduaghan satirical apology. He say that one dey different from the issue of her suspension. He come explain say the contempt charge e require a specific apology to the Senate and not be the court. When they come ask am about the required apology, Maduabuchi come confirm. He say you have to apologize to the Senate. He say then now, in fact now, in trying to apologize, she come begin to refer to the satirical nature of her previous apology attempt. He say na contradicting claims by Senate lawyers that no clear order was given for the senator recall. Maduabuchi dey emphatic about the court directive. He say no be true. He say the judge dey very clear. He say the judge don talk say the thing dey excessive. He say the people now dey deny them representation. Go back to your work. Say na so the judge talk. The senior advocate come acknowledge practical difficulties to implement the judgment, particularly as e regard access to the Senate chambers. He say if she come, he say they must give her access by the sergeant at arms. Who go say no because I never see the judgment? Maduabuchi come explain, and he come dey note say why the senator get the right to return, security personnel also get legitimate concerns to implement orders when they never see. As he come dey address the Senate position, say Akpoti-Uduaghan must apologize before they go reinstate am. Maduabuchi come clarify the proper legal procedure. He say if Natasha don flout the order of a court, he say dem get lawyers, dem know wetin dem go do. He say if she flouts the order of the court, he say you no go do am by your own recklessness. He come advise, he come explain say the proper procedure go involve to issue formal notices and to seek court intervention rather than to take unilateral action. Maduabuchi come express broader concerns about clarity for judicial pronouncement. Come dey note say e don dey become a pattern of ambiguous judgment. Na be judgment wey e no clear to interpret. Say the first thing you must realize about court is certainty. Once the judgment don lose that trait of certainty, e say e go become something else. Say that na why we dey here, because e get some things wey they need to clear now, and that na wetin judges dey try to avoid. Say that na him observation. The senior advocate come draw parallels with other controversial judicial statements, including references to passing statements by Supreme Court judges when e don lead to significant constitutional crisis. E come distinguish between formal court orders and wetin lawyers dey call orbital dictum, when e be passing remarks when e not dey backed by the force of law. Maduabuchi come emphasize say fundamental constitutional principles when e regard the separation of powers and the role of courts for democracy. He say the court no be legislator. He come stress dey argue say when parliament don grant discretionary powers to institutions like the Senate, he say make court no second guess those decisions unless they violate constitutional provisions. This na a sound piece of counsel from a legal counselor, that the court no be legislator, and na good opinion too when he make in our consideration. Say some of these judgments dem no dey clear cut, so e go dey cause ambiguity, e go dey cause matters arising like wetin don dey now, because this tension now when e don dey for ground between suspended Senator Natasha and the Senate, like Maduabuchi don explain, e go hard, because the people when e go implement the order, they go talk say they never see the order of the court. People like the Sergeant at Arms and peradventure the clerk of the National Assembly. Now only time go tell how this matter go finally gain resolution. You see am.